处在也有一个就是对于知识产权保护的问题。那么我们现在也在制定指南，就是来试图去界定，就是竞争执法与知识产权保护之间的界限究竟在哪儿啊？那么这些都是我们中国现在所面临的主要的问题。谢谢。
Thank you for that, quite comprehensive. Can I turn now to Cecilio? 2 weeks ago at the Global Forum of the OECD, there was a lot of discussion and debate around disruptive technologies. And perhaps you could maybe share some of those views or some of those comments and the European Commission's approach towards disruptive technologies.
Thank you, Oliver, for your very short introduction. I was not at this OECD meeting, but of course by the way, there are good representatives here of the OECD. But of course, I'm aware of what we discussed there because I contributed to the works of this session. Probably I should start by saying, because I shouldn't forget that I'm a public official, that most of, not to say what I'm going to say today, what I said 2 days ago should be attributed to me, not necessarily to the institution that I represent for obvious reasons. First thing I would like to say is that certainly the European Union is not coming to this, by the way, very well organized conference and of a very high level with the idea of teaching anything to anybody. What I mean by that is that there is no single way to look at innovation from a competition policy perspective. Every country, every authority might have its own perception, and still I think that there are some principles that we all agree or we should agree on, and I think that it's fair to say that growth and innovation are at the top of any government competition policy because they are key drivers for productivity and investment. In other terms, I think that growth and investment lead to a more efficient use of resources, to reduce cost for all of us, to increase choice in the type of products or services that we get, lower prices, which is not necessarily bad, and more competitivity for our economies. By the way, this is one of the key, let's say, targets of the OCDE, to create the conditions for a more open economy and liberalized markets. And the experience, although I was clear in saying that I don't intend to teach or to put the European Union as an example, our own experience tells us that the liberalizations of key markets like the air transport, telecoms, and the energy markets in Europe have provided a lot of benefits to our consumers and to our economies as a whole. Don't misunderstand me. I'm not saying that these three sectors, and in particular the energy market, are already perfect and that the liberalization is sufficient. I'm not saying that, but it is obvious that the Commission has a policy trying to create the condition for a more liberalized, markets because of the benefits that I have just mentioned before. I think, as Alan has said before, at the beginning of this panel, innovation is probably, I would say even certainly, the single most important input factor. By the way, my colleague and chief economist from the DG Competition is just in front of me. He should be reassured that I'm doing efforts to speak like an economist. I don't know if I will succeed. But it's true, and I'm convinced that innovation is the most important input factor contributing to economic growth. And this is the truth in Brussels, in Madrid, or in Durban. By the way, I was impressed yesterday by the stadium that you have, and also And I would like to mention this not because I'm supposed to be polite, as I tried to be 2 days ago, but because I was very impressed by the words that your minister, Mr. Patel, said yesterday about the 6 eyes that he explained. By the way, it's probably one of the first dinners where I see that the whole audience listen to the speaker instead of concentrating on other things, which certainly says how good his speech was. But I retain 2 I's that he used and that I understand are important, particularly in this conference, which are inclusion and integration. I think that integration, as Minister Patel referred to it, implies, and it would be good, an integration of the South African countries in a bigger organization, precisely in order to create a condition for further growth and more cohesion in this key part of the world, but also inclusion. Inclusion meaning by that and this is let's say, the most problematic thing that national government might have, which is to make sure that innovation is not hindered, while at the same time you protect, you include in this innovative market or in this enhanced economy those who are not necessarily capable of competing with these new disruptive business models. Again, and I said that with other words in my previous intervention 2 days ago, I think that nobody challenges the idea that we should go for a sort of balance of what is a very competitive market with also the protection of what I would call consumer rights. And this is, I could mention some of them. I think that it is a legitimate public policy, and these are legitimate public policy objectives to avoid free riding of innovative technologies. I will come back to this afterwards if you have a moment. To protect, as I said before, consumers. To assure a level playing field for those who are competing in a market. But I think it's also important to, and I'm having in mind, for example, Uber, which is now a very disruptive, innovative business model. Well, I think that it is not fair to simply stop Uber from, I'm talking on personal basis, I've said, from making businesses here in Europe or wherever there is demand for it, simply because they challenge the position of the incumbents. But at the same time, I think it's fair to ask these new business models to guarantee a minimum of safety for those who use, for example, Uber. We need to protect consumers' interests, and they have to pay, just to give you some, as I said, legitimate public objective targets, they have to pay taxes as incumbents or already existing competitors pay in our respective jurisdictions. Why I was mentioning as legitimate public policy objectives to protect from free riding? For 2 reasons. First of all, because I believe that if an innovation is really disruptive, the conditions have to be created, if I may say, or assure that this innovation gets the benefits precisely of this effort of innovation that has been undertaken. And it has to be protected, as in general any innovation, so that we avoid free riding or access to technology which by definition is protected in order to favor, I don't know what type of alternative competitors or the interests of a specific national competitors. I don't think that this is something acceptable. At the same time, it is obvious that it is not because someone has a very good product or has been capable of getting into the market in such a way that its market share is increasing on daily basis, and that there are occasions and there are new business models where you see that competitors are not fighting for big part of the market, but for the market itself. And I think that is there where I would like to say that from a consumer welfare perspective, also from a competition policy perspective as an enforcer, and I represent one of them, the most dangerous monopoly position, in my opinion, is the one that monopolizes innovation. I still remember the investigation that we ran for years in the early 90s against specific abuses that were considered as such by the Commission and confirmed by the court in Luxembourg involving Microsoft. You know that we had for years a long investigation. And I still remember, and it was very legitimate from Microsoft's representatives to tell us, you cannot deny that we are innovating. So if we are innovating with our Windows operating system, why you care about what we are doing? And the answer that we provided, unfortunately, was accepted also by our courts in Europe, is you have the right to innovate, and we are happy when dominant players innovate. But as I said before, the most dangerous position is one where the innovation is also a sort of monopoly, provided by the one who controls the market. So I think, and with this I conclude, because the idea, I guess, is short answers and then possibility of cross-examination, if I may say. I think that as a competition enforcer, my suggestion, but I repeat this again, a personal opinion, is twofold. Antitrust enforcers should be far, very far from competition tools in order to stop innovation. We should only intervene when there are abusive conducts which can be demonstrated. Two, I don't think that we should intervene with our competition rules here in Brussels, in US, China, wherever, if we cannot prove harm, meaning by that real harm, not theoretical representation of what it would be an ideal market for a national government or for a competition policy, competition authority. Real harm to consumers, to the economy, to the innovative growth which is indispensable everywhere in the world. And at the same time, I think, as I said before, that we need to make sure that competition enforcers, as I said, intervene only when it is indispensable. But when they do it, I think that they should also keep in mind the respect of what it is a British English concept, the famous rule of law. I think that we all, meaning by that competition authorities, national governments, we should be subject to the rule of law, to the idea that the legal principles are applicable to everybody, including those who decide what are the main perspectives of a national economy. We should make sure that in the way in which we apply our rules, we respect due process, right of defense. I mean, an innovative, small or big company, a large company or a small company with a marginal degree of innovation. Any company has right to a proper defense in front of national competition authorities. And I think that it is important also to avoid, and this is something that in Europe, don't forget that the European Union is the union of 28 member states. We try also to avoid discrimination between national and non-national companies. As I said 2 days ago, we do not look into the flag of those who come to file a complaint against another company in Brussels, or we don't look into the color of the flag of the company that we are investigating. We try to do our competition assessment on the basis of hopefully sound economic principles, well-established legal jurisprudence brought to us by the courts in Luxembourg, the General Court and the Court of Justice, and we do our best to avoid discrimination among European and non-European players, but also within European companies, we avoid any type of differentiation between public and non-public owned companies, because we believe that if the idea is to create or to make sure that growth and innovation guide our economies and the indispensable development of our economies and of our citizens, we need to apply our rules with prudence when it is indispensable, and in any case, with a very clear understanding that due process and no discrimination is fundamental. Thanks.
Can I now turn to my colleague in South Africa? I think the observation is that, disruptive technologies has not been on the radar of the South African competition authorities. Do you think that might perhaps change going forward, given the prevalence of the focus, elsewhere in the globe?
I'm not sure if I'll be able to answer the question in one sentence. So if I can just go back a little bit while I was listening to my colleagues here on the panel, what struck me was that the underlying driver of disruptive services in the modern world is actually telecommunications. And if you look at the innovations over the last few years in that technology, you can see that it underpins a fair amount of disruptive businesses, bringing in new products, new services, a whole range of things. But I just want to step back a little bit. Recently, the South African Competition Commission brought a case to us. Well, it's a case that ran for about 10 years in our authorities. And it was an abuse of dominance case involving our legal monopoly telco. I think most developing countries in the BRICS have always had a legal monopoly for a few years and a sector regulator attempting to price regulate them. In our case, the abuse of dominance allegations were refusal to deal, margin squeeze, and refusal to supply an essential facility. The case ran for 10 years for a number of reasons, mainly because the respondents took quite a few technical legal points and played the Commission's jurisdiction out in other courts. We eventually heard the case, the first case, imposed a fine of 449 million rand on the telco, and had a second case which came up to the tribunal as a settlement. And the settlement was a very creative remedy. It was a remedy that essentially created a functional separation between wholesale and retail for internet services, for access for internet service providers. And when we imposed that settlement as an order of the tribunal, I asked myself, so is this still relevant? Is this separation that everybody has been wanting for the last 10 years, which the sector regulator could not get right itself, and here we finally, get what we wanted 10 years ago, and I say, is this still relevant? Because in South Africa, we have these generation that are called born frees. These are people who were born after 1994. But we also have the telco-born frees, those people who've never actually used a fixed line telephone ever in their life or have seen one. And so they would ask, is this relevant? And what is this telecom case about? And of course, it is still relevant because at the underpinnings of this case is mobile. It's mobile technology. Mobile technology has legendary innovation in South Africa and in BRICS countries. You look around you and you can see the kind of services that we've been able to develop, which are critical for developing countries because they relate to health delivery, delivery of power, meaning electricity, gas, in some instances water. But mobile is only possible because you need the backhaul of fixed line. And it's become increasingly relevant with new technologies which are emerging on mobile, which are all related to data speeds. So going forward, we're going to see, in fact, quite a lot of, I think, disruptive services which are going to be on mobile. And as an example for South Africa, recently we saw a demonstration of university students. And there was a cartoon that said, "The revolution has been tweeted." Twitter was able to bring together 1 million young university students, which no newspaper could do. So as a simple example of impact on firstly creating new ways of bringing people together, therefore new products and services, and therefore new markets, but also killing off other markets. The business case for print newspaper is dead, for example. You know, online shopping is as China has been talking about, taking over a fair amount of mortar and bricks kind of retailers, especially in the sort of middle segments. So I think we're not engaging enough, if you want to know, with innovation and disruptive services. We should try to do a lot more market research and look at where these kinds of technologies are going, excuse me, so that we can at least anticipate the kinds of anti-competitive behavior that we could see emerging in those kinds of environments.
Turn to Ellen now, and given what we heard from the panelists, around disruptive technologies and how fast, these technologies can actually grow, do you think perhaps that competition law and competition policy has been rigid, or has it been flexible to cope with these fast-paced technologies, especially these disruptive technologies?
Okay. Well, in a word, competition law, I think, is okay. Competition policy, in the broadest sense, faces a challenge, but I'm using the word competition policy to embrace regulation. We need to act as competition people to make sure that regulation doesn't get in the way. So to give you an example, taxis. Now, there are two problems with the taxi regulation from the point of optimizing the use of innovative technology. The first is that the whole system of taxi regulation in most jurisdictions around the world is designed to keep new players out. It's simply set up licensing and other such restrictions, and that keeps the new players out. In most countries, Uber has had to break the law to crash through. I don't think there's any possibility that Uber would have got to its present position of market capital of 40 billion, a presence in over 350 cities in 60 countries, if it had gone cap in hand to the regulators of the taxi industry and asked for permission. The whole system of taxi regulation is designed to protect the incumbents. But the second problem with the system of regulation is also that it is based on a model that assumes there's only one way of doing business. It assumes you have metered cars and things like that. Now, Uber has brought in a new way of doing business. They don't have meters in cars. They have credit card bookings. They have other ways of keeping you informed. And they also have a different approach to pricing. They have surge pricing, peak load pricing and things like that. They don't require drivers to be on shifts, and a whole lot of innovations, so that even if the taxi industry sort of removed entry restrictions, the actual imposition of the established regulation is totally restrictive and so on. So the challenge is, because as you mentioned, there still are some regulatory issues, safety. Another one that really needs consideration is the treatment of people with a disability. They really do have special needs in the market, and we need to have a system of operating the taxi industry, or shall I call it point-to-point transportation services that caters to their needs in some fashion, whether through regulation or government subsidy or whatever. So going back to the point about competition law, I think one of the great things about competition law is that it is based on concepts that make it highly adaptable to new technology and to change. The concepts of competition and market power and abuse of market power and so on, the key concepts are ones that can deal with change. A market definition, for example, can change as circumstances change. Our view of what's abuse or what's an anti-competitive practice can change because our concepts are very flexible. So I start from the position that on the whole, competition law is adequately set up to deal with the new technology. Regulation generally is not well set up.
Let me turn again to my colleague from South Africa, Yasmin. We've heard yesterday that there was a lot of emphasis on, in addition to your traditional competition principles, but also the public interest. We heard a lot about the public interest, and there is some consensus that in developing countries, the public interest is quite important. Now, can you tell us, maybe from a perspective of innovative remedies, and perhaps I want you to focus maybe more specifically on private agreements, because you do get sometimes a public interest that's slightly outside the ambit of the Competition Act, and you may find, for example, in a merger, that the merging parties themselves or interveners, like government departments, may bring a private agreement to the tribunal, together with, obviously, the recommendation that might come from the Commission itself. And how does the Competition Tribunal deal with these private agreements that actually promote the public interest?
Well, I'd say on a case-by-case basis. I mean, I think that Oliver wasn't teasing when he said there will be some controversy. I can't think of how to dovetail this in the growth and innovation topic. But one of the issues that did come to mind was a case that was discussed earlier today in the first session, and I know that we've touched on it quite significantly in other sessions as well. It was the Walmart case, of course. And in that, the growth and innovation aspect really was, to my mind, was in the local markets, the local producer markets. I think that not only has that condition promoted local production and for Walmart itself, but has also placed those producers on a global market because they've actually started taking their produce to other markets in the global network. So I can think of the usefulness of, where those kinds of public interest remedies can promote growth and innovation, but I think that they're on a case-by-case basis.
I fully agree with Jasmine, so I'm not going to repeat the same thing, that this type of very tricky questions, and in particular when public interest is duly respected or not, or attained, can only be seen on a case-by-case basis. I think it's very bad to have a sort of pre-established ideological idea of what is good for our economy without looking into the objective essentials, I would say, of the case. which is brought to our attention. I have the feeling, and in any case, I'm talking about the experience in Europe, that a monopoly and efficiency are two words which go together very, very smoothly. So I think that in the current globalized economy, growth and innovation are principles which are applicable in Durban, in Johannesburg, in Paris, and everywhere. And we should try with our respective policies to create the condition for growth, innovation, and for inclusion of our citizens in a globalized economy where, at the same time, it's obvious that we need to make sure that, as I said before, we avoid the abuses or situation of privilege which go against the interests of countries and consumers. I cannot agree more with what Alan said also about regulation. I think that to try to regulate innovation is like trying to put doors to the sea or to the ocean, which is so close to us here. In Europe, I have a case in mind, but it's probably not necessary to give names. In Europe, we are telling our own constituency, our own governments, do not regulate very innovative businesses for the sake of protecting, I don't know what type of interest, without having let competition authorities, and in particular the European Commission, to see whether, with the implementation of competition rules, we can avoid the type of abusive conduct that you can expect, you can consider some platforms, IT platforms, might be tempted to let's say, engage in. But at the same time, and that's why I believe that we should not be frightened at the idea of having a case-by-case approach, but also a global picture of what we are doing. The difficulty is to strike a balance between letting innovative disruptors to get in and take a big part of a new market, because at the end of the day, they are inventing new business models, and at the same time try to protect citizens and also competitors in a way which is fair enough for everybody. And it's easier to say that than to do it really. I give you an example. Uber, as Alan was mentioning, has now a very relevant presence in many countries across the world. At the same time, I can understand that national authorities, not necessarily competition authorities, are asking Uber to make sure that the drivers that they use are sort of professional. I mean, that when I take one of these Uber cards, I expect to reach my destination, and for this, probably I need someone who is capable of driving conveniently. I would also expect this driver to have a decent insurance, because if there is something wrong happening, and it could happen, I'm supposed to be protected. And at the same time, we have also to make sure that these new business models pay taxes. It's something that is indispensable for the continuation of our economies. And these are things that are not so, I'm not talking about Uber in particular, but this type of legitimate objective have to be assured in order to make sure that when you compare old business models with the new ones, there is some fairness, if I may say, in this comparison. And last but not least, and frankly speaking, I have no answer to this question, consider the case of taximen, individuals, who own a taxi, who make their families live with this taxi, who have paid a huge amount of money for the license, driver license that they have, and who need now suddenly to incorporate or to compete with a completely new business model, which is very difficult for them to compete with. I said I have no answer to this type of very specific situations, but some degree of balance should be found, I guess.
Oliver, I think that the discussion on Uber has been very interesting, but I think that for us in developing countries, there are certain considerations of public safety, not from a driver insurance kind of angle, as Cecilia was saying, but we have taxi wars, you know, and we have to think about the public interest of regulation for that purpose. I just want to come back to the earlier question you asked, and perhaps the shift towards public interest was perhaps a bit too narrow in what you were trying to get to in terms of growth and innovation. I think creative remedies is a very good way for competition agencies to assess whether A, they are able to achieve competition as an enabler of growth and innovation, and to understand the impact of the work. Because sometimes when we sit here and we say, well, we know we want to promote competition, but we really can't assess whether our enforcement has any impact. And in recent years, the tribunal, certainly in South Africa, has utilized a number of creative remedies to promote entry, for example. In a fertilizer case, you know, there was a divestiture and we had a new entrant. And when enforcement of cartels, aside from the deterrent effect of penalties, we've imposed discounts, settlements where there's been discounts to market, and investment in certain agro-processing funds. So I think that perhaps as competition agencies, we should be also looking at creative remedies as a way to promote growth and innovation and entry into markets.
Thank you, that was excellent. All right, I think we've sort of run out of time, and I did promise that you know, we'll take one or two questions from the audience. Can I quickly check if there's one or two questions from the audience? And thereafter, I'll just ask the panel to, you know, in perhaps 1 minute, just to give their concluding remarks. Okay, I don't really see any hands. Am I not seeing any hands? I think it's Friday, yeah? All right, you've exhausted, and all right. No problem. Okay, let me conclude very quickly, and maybe start from my colleague here, Hong. Maybe just 1 minute concluding remarks.
好，我们今天谈了一个大的话题，实际上落在我们每一个发展中国家，就金砖5国的发展中国家，中国是最大的发展中国家，既有共性的问题，又有差异的问题。从刚才最后我们所讨论的，我们一直几位嘉宾所讨论的这个 Uber 的这种案件来讲。 几个法域我们都看到，都遇到同样的问题，但是这种同样的问题，可能它对于每一个国家，甚至在中国，因为非常的大，它对于每一个城市来讲，可能它的意义都不一样。而且我们现在谈的 Uber， 实际上中国在 Uber 之前，我们已经有类似于 Uber 的这样的公司，那么我们也允许 Uber 进到中国来，那么实际上他们之间都是在竞争的，但是会引发新的问题，对传统的管制行业、许可行业都是一个大的一个挑战。这仅仅是一个例子。那么总结来讲，中国现在是最大的这种转型国家，从一个计划经济向市场化转型的一个过程。我们的过程从我们的30年的经验来看，市场化。 也就是竞争给我们的市场释放出巨大的红利，那么也是可以，我们现在可以看到，中国是最大的贸易国，也是最大的投资国之一。因此，我们中国在下一步的转型，我们已经得到了这种市场上给我们的经验，我们的消费者也因为市场而得到了巨大的这种好处。 那下一步的发展，我想还是一个需要进一步的竞争政策的它的地位在我们国家的这种提升。那么同时，在这个过程中，经济发展不能 仅仅依靠政府的这种政府主导的产业政策，而更好的去发挥市场的红利，并且创造这种公平竞争的这种环境，来使得我们真正的市场的创新达到一个最大的一个进步。那么在这里头，对于这种创新的保护，不仅仅是来自于我们竞争执法的保护，那么还有最基础的这种保护，还是这种私权利的这种保护的机制，特别是这种知识产权的这种保护的机制。那么我们国家在若干年前已经把这种知识产权的保护的这种制度，已经上升到一个国家战略的一个地位。那么也可想而知，就是从一个私权的制度上进行保护，这是一个规则性的保护，这个是一个基础。那么再加上竞争执法的来去判断它的这种边界那么创造一个公平竞争的这种环境，大的环境是一个保护的一个整体。创新需要一个制度的系统性的一个生态的一个制度。那么这也是我们未来所追求的目标。谢谢。
I talk about Uber because it's something that has been discussed by other panelists, not because it's one of my main, let's say, examples or priorities. I'm saying that because, for example, in 2014, we approved a merger in Europe, the European Commission, between two well-known companies, Facebook and WhatsApp. And as you know, or probably if you don't know, I tell you, it was not very welcome by European telecom incumbents in Europe. Again, this idea that we don't look into flags, because they thought that the two merged companies would create a sort of business model very difficult for them to tackle. And still the Commission, I'm talking about 2014, so last year, we approved it because we came to the conclusion that these were two innovators bringing a lot of innovation to the market. And also, we came to the conclusion that we could do what we did, which is to approve it, because we know that the number of applications which has been developed by many engineers, many companies, is increasing, and that all of us, meaning by that you and me, we go for what we call multi-homing, meaning by that we use multiple ways of communicating and not necessarily those represented by these two companies. So I think that, as Jasmine said before, is a case-by-case approach which makes things more predictable or fair in any case. It's pretty important to keep in mind that 1 year, this is something I have read from eminent professors, and I have one here on my right, 1 year in real time equals 7 years in high-tech markets. By the way, Oliver, we won't have time today, although we discussed it yesterday. But one question that we should ask ourselves, antitrust enforcers, is whether with our remedies, when we adopt them, we come with them timely, or the market has already shifted or moved when we come with our decision. But this is for another day, for another seminar. But if the evolution of market is so quick, 1 year equals 7 years, as I said before, what we have to do is, as competition authorities, is to make sure that we intervene only when it is indispensable, but certainly do it when it is indispensable, and move as quickly as we can if we want to make some difference, if we want to make some meaningful changes in our economies, or if we want to create the condition for a level playing field, as I believe is a principle that we all agree on. Thanks.
Yasmin?
Thanks, Oliver. I think that the discussion here makes me think about where one can see services going in a highly technological world, and that we could perhaps see the development of multi-sided markets, not just 2 or 3-sided markets. And I think that what might be good for competition agencies, certainly in the BRICS and developing countries, is to perhaps invest a little bit more money in market research and look at growing and developing markets, because it is difficult for us to post-enforcement to do an impact study when it's much more expensive, and perhaps it might be better to invest up front and start looking at where the trends are going so that we can also keep a pace with innovation.
Alan, final remarks?
Well, various interesting comments have been made. On the tax question, there's a very interesting article in the latest Bloomberg or Business Week about the mechanisms by which Uber pays very, very little tax. And essentially, it's the exploitation of the intellectual property value that underlies the Uber model. And it is fairly easy to transfer the charges and costs for the IP value of Uber to low tax jurisdictions. On the question of what to do to protect incumbents in the taxi industry, I mentioned 2 points. First, that it is useful to distinguish between the pre-booked market, where we book by phone or internet, and the rank and hail market, where we get taxis in the street. The new businesses are in the pre-booked market, and I think there's quite a strong case for removing much of the regulation there, because there's more competition, there's more choice, there's more information for the consumer, there's better safety than in the rank and hail market. So I would encourage a policy distinction between those two sorts of markets. Regarding the licensing, in my town, Melbourne, we made some progress by saying that the government should not set the number of taxis there should be in the market, remove the quantitative restriction. But because that would have reduced licence values from $500,000 to nothing overnight, we said that people should pay for new licences about $20,000 a year. That means if you've got an old licence, you can continue to allocate it to someone for about $22,000 a year. So we halved the value of licences overnight from $525,000 to $280,000. And of course there was many protests from the industry, but that was the balance. Cecilio said, could you strike a balance? That was the balance we tried to talk about. So I just conclude with 2 general points. I did earlier say, well, competition law has got a set of concepts that adapt well to technological change, and I believe that. The challenge, of course, is for the competition regulators and the competition world to be able to manage the knowledge about new technology well. Can we recognise the distinctions between different forms of technology that will have different effects on competition? So we've got the right concepts. Do we have the knowledge to apply them? Now, the final point I wanted to make is, do we, competition regulators, face some disruptive technology affecting us? So I'll just go back to the famous views of the Austrian economist Schumpeter, who said that we could always be sure that there would be waves of creative destruction that would wipe out all monopoly power, that new technology would always strike down established power, but he added a slightly less pleasant message for competition regulators, that he didn't believe they were ever necessary. Technology would always do the job in getting rid of monopoly.
Thank you, thank you. All right, I think we ran out of time, and I think, the short period that we had to discuss this important topic, it's quite obvious that we could not finalize these discussions, and I'm sure that these discussions will evolve at other forums as well. So let me just take this opportunity to thank this distinguished panel of experts on this topic, and can you please give them a round of applause? Thank you very much, and I believe it's lunch now.